PRA and the PDC, yes, a whole alphabet soup, and by the end of the day, we'll understand what all those mean. So first and foremost, I am going to start with the OPMA first and foremost. We are in an open public meeting right now. And I'm going to explain what our requirements are when we meet as a board and what is expected. So the law basically says that as a public agency, we are permitted to meet. Persons of the public are permitted to attend our meetings of the governing body of the agency as otherwise provided in the law. And interestingly enough, this obviously applies to school districts. And we have to be in open and public unless the meeting is allowed to be closed, which I'll cover. Interestingly enough, the courts and the legislature are not subjected to the OPMA. I don't know why they exempted themselves, but they are not subjected to it. But we are. One important caveat, and we probably have already been in one of these before, and so you're aware of it. There are certain types of things that are exempt from the OPMA, which means you don't need to notify the public, you don't need the notification requirement. It's not an executive session. And oftentimes we get confused about what is an exempt session and what is an executive session. This list, exempt session, are matters in which we don't need to be subjected to the OPMA. It's pretty limited. The first is quasi-judicial. Believe it or not, we've already been in quasi-judicial. This is where the board had a hearing and we took evidence. Okay, so in any posture where the board is hearing evidence and rendering a decision as like a judge or a body where we issue a decision, that is considered a quasi-judicial proceeding. It's exempt from the OPMA. We can do that, we can deliberate, and we can reach a decision, and we don't need to note that for the public. Okay, that's the first one. So that could be a student appeal situation, that could be an appeal from an employee matter like the one we had not too long ago, or any of the other matters that come under board policy that come to us. Okay, any questions there? All right, the second one is probably where in the next coming months we're going to see a lot more of, and that's certain collective bargaining updates, planning for negotiations, grievance and meetings proceedings where we are discussing responses to grievances, where we're discussing collective bargaining. That would be also an exempt session. Okay. Next slide, I want to just discuss what is considered a meeting. And we can talk about, okay, we go to the WASA conference and we're all there eating lunch. Is that a meeting? Or we're in the car together. Is that a meeting? Or we're at a restaurant together. Is that a meeting? And we're going to put some guidelines together as to what can we do to protect ourselves against having potentially a meeting when we're not intending to have a meeting. A meeting occurs, as defined by law, when you have a collective intent to meet, where you have a majority of the members together with the purpose of collecting or conducting or transacting business. So if you've got more than a quorum, which is 3, and you're there, and you're potentially discussing the work of the district, that by itself could be considered a meeting, right? And that would apply to retreats, workshops, study sessions. Those are synonymous with meetings. So although we're a work session here, this is still a meeting. That's why we're open to the public. Now, there could be many things that you go to. You could go to a performance at the high school, and you could all be there. Why is that not a meeting? Well, are you there with the collective intent to meet, to transact the governing body's official business? No, you're there to watch a performance of Greece. Great, that's not a meeting. But let's talk about what that might look like if it looked like you were conducting business. A board member comes up to you and starts discussing, hey, how are you going to vote on that? Oh, that potentially could be a problem. You've got 3 or 4 board members there. You're deliberating, you're discussing. You could see how that could be a problem, right? So I know this is supposed to be a little bit more interactive, so I'm going to throw it out there. Any thoughts from any existing board members that have had this issue come up before, how to best avoid that appearance of maybe conducting a meeting or conducting business while out there in public? Any thoughts?
We usually, if we know that there's going to be an event coming up, we will just disclose it and put it on the book. So if Cambridge is doing a play, or we had our Martin Luther King assembly and all of us decided that we were going to go to that, we just, even though there wasn't going to be a meeting and there was no business discussed, we still put it on because we knew everybody was going to come. If it just happened that we all ended up being there, I would probably be, hey Andy, how's it going? And then let him sit on one side of the room and I would probably sit on the other. Not because I don't like Andy, but because then there's no difference.
Yeah. So kind of 2 layers of protection there. One is that you're noting it as a meeting, but 2, you're also being very careful to to not discuss matters that potentially could be, right? That's great. Any other thoughts on that? Okay, we understand that. It's not considered a meeting if no action is taken, but I would say, we're going to define action in a second. We probably think in our heads, action means resolution. Action can also mean deliberation, discussions, that could also be action. So note that action could be more than just taking final action. I'm going to talk about some really interesting scenarios here that I want you to be aware of, what's called a serial meeting. The cases are more recent, talking about potentially where a series of smaller gatherings or communications over like email, even though they're done separately, when put together could constitute a meeting. And that's most likely done over email or text message. And I'll talk here in a second about text messages when we talk about PRA, public records, why it's probably not in our best interest to use our personal cell phones to conduct agency business. But that said, we really need to be careful over email, because a serial meeting can occur with or without technology. But what happens is, it's because you're not in the same time and the place, but you're conducting that business over a series of emails when put together would constitute a meeting. And so basically, the biggest example of that would be reply all. If you're replying all or trying to discuss things on email, that could get into the territory of a serial meeting, right? We've all have lived in the business world and seen the reply all of emails, especially in this context, be very dangerous. Now, the second bullet point is true, the big bullet point. Passive receipt of email. So if you're just getting information, the information is being sent to you, it's not considered a meeting, or it's not a serial meeting. It's when there's that response, deliberation, back and forth, communication back and forth, where we can get in that situation, okay? Last point, this can apply to text messages or any other social media platform that you can imagine. Facebook comments, anything else where we're in there conducting comments and we're all in there together, even if you're in your personal capacity as a community member, that could potentially constitute a serial meeting, okay? Make sense? Questions? We understand that, Tim? And then
I have a question, but it's actually the previous.
Yeah, right there. There we go. Yeah.
So it's not serial meeting, but when I served on the city council, the issue of OPA was questioned in terms of us gathering to eat together as a group, which was back in the council chambers. And the direction I got from legal was, as long as a staff member is present and there are no discussions and you have a witness to that, you're covered, because we do have to eat for 4 long meetings. And when I found myself in the back room right before a meeting, and there were, eventually there's 2 of us, and then in comes that third, to avoid that, either one of us has to leave. But could we not also substitute if Wade came in?
Yeah. Yeah, there are layers of protection. There are different ways to handle it. One way would be, as President Margell suggested, we announce it as a meeting. Certainly do that within the open forum. You can also meet and not discuss the district, and make sure your conversations do not go into that direction. Also, having a member of the district there to remind us of that obligation is certainly helpful. I would also just throw out there, even without the requirements of the OPMA, the public's watching. And if they see the board go into a restaurant, into a back room that's closed, and then close the doors, the public might say, well, what's happening there? And so appearances matter. And so I would just be very mindful of that requirement, that even though you're not needing to conduct a meeting, the public might think you are. And we want to err on the side of transparency. Great points there, and I agree with the recommendation from the city council. So just be very yes, or President Margell. Yeah.
With the emails, you said, talking about discussing and taking action. We're all going to meet at WASDA at 7:30 for breakfast at Starbucks. And Superintendent Bailey sends that out to us, and and we say, wait, which Starbucks, reply all, and we had to go back and forth just figuring out what Starbucks. All we're talking about is,
Yeah.
you know, that wouldn't be a violation because there was no action taken,
Yeah.
this is not.
So, action or final action is what is the official transaction of business. And right here is a list of what could be constituted as action. Receipt of public testimony, deliberations, discussions, considerations, reviews, evaluations, and final action. So some of those kind of preliminary conversations of, hey, where are you at? Are we coming? That sort of thing would not be for the purposes of deliberations and discussions in that matter. So I think you're safe there, because you're not deliberating a position of the district on something of substance. It's more setting up a meeting or something like that. But I would still be careful.
Okay.
I would still be careful. But if the email itself is not to a substantive deliberation or discussion, you're safe. Okay. Go back a little bit. This is just an example of, again, I'm not going to read all these cases, but they're in your materials, in which there are examples of serial meetings in which it was more than just a mere passive receipt of information, and so they're exchanging actual information and opinions, and that made it a meeting. Okay. And that's what action could be. Final action, just to be aware, there are times where we're in executive session. Maybe we're talking about the superintendent contract, and we have to take action on the contract in open session. Maybe we're, voting on a contract there. We can't take secret ballots or vote in executive session. That has to be done in open session. We can have conversations in executive session on performance of a public employee for the superintendent, but that actual action has to be taken in open session. Okay? Even like, hey, how are we leading? Let's take a secret vote and just see where, no, that needs to be done in open session. Okay? And so the discussion might take place in executive session, but the action, the approval of the contract, for example, has to be taken in open session. This is an interesting case in which it was basically a secret balloting where they kind of took polls and votes, and that wasn't allowed. Okay. So just as we're talking about emails, so let me just send out this hypothetical situation. Tell me how you would react. I'm sure none of you have received this before. An email is sent to all board members separately from a community member asking to take a position on an employment matter. So you and your position received, a member of the community has sent you an email. How should the board respond? Should the board make a collective decision or respond to the community member? What do you think? Any thoughts on this purely hypothetical situation that probably will never come up?
I mean, right now, our standard procedure is just the board president does the response call.
Yeah, I like that. So when I talk about communication protocols, and I haven't dug into really, I've only been here for a couple weeks, but you want to think deliberately about, one, how are we responding to the community? Is it 5 separate responses with 5 separate, or do you have an actual protocol of, say, the board president engaging and, redirecting to the appropriate place? Because I think you want to be very careful about, one, 5 separate responses, right? There's an issue there. Collectively taking a position on a matter. So let's say the board deliberates and then comes back and says, here's what we're going to do. Okay, that's going to violate the OPMA. And also, you have staff members. You have HR and staff members that are handling this, and certainly you want to be in line with staff as well. So there's kind of 3 separate issues there that you want to be mindful of. Does that make sense? The director saw a great response there in terms of following our protocols. Okay? Certainly that could touch the OPMA. We talked about this a little bit, but travel, you're going to watch the conference, hotel, you're going out to eat. You can travel, you can gather together for a private or a public event, so long as no action or discussing of agency business. Remember, action is more than just a resolution, it's about deliberations, all of that, right? And so 2 ways that you said you can handle it, President Margell alluded to, you could actually put it as a meeting, or you can just make sure you're not discussing any agency business. You can attend another agency meeting together as a quorum, so long as you don't take action, and certainly if you're less than a quorum, just 2 board members, that's another story. Right? Any questions there? All right, so our regular meetings are held in accordance with the schedule of the board of directors. Regular meeting agendas are posted online within 24 hours. Regular meetings, and this is something that does come up from time and again, is We can amend an agenda on a regular meeting, we can't on a special meeting. Okay, so we can walk up a change on a regular meeting if we need to change the agenda, and you'll hear that noted when Superintendent Vela asks if there's any changes to the agenda. You can do that at a regular meeting, you can't do that in a special meeting.
Is that including extending time?
Extending time, that's really, I think, because time, I think you can extend time, because you're not adding an agenda item. I think that's allowable, right? It's more going to the notice when they don't know what's gonna be on the agenda for a special meeting, and so just allowing more time doesn't really, it doesn't trigger that notice, like, is something gonna be discussed in a meeting that the public's not gonna know about, right?
We have that question.
Yeah, okay, so special meetings have a certain 24-hour notice requirement, time, place, and because this is not a normal meeting, provided to the members of the governing body. You provide, of course, the local newspaper, radio, TV stations, and you prominently display that. So it needs to be announced, website, right? And again, what I noted here that's not the notice is we can't modify that agenda because of that notice requirement. It can't be modified that day of. Emergency special meetings don't come up that much, but that's when there's an injury or damage to personal property. And courts have said it does not include a response to a potential teacher strike. We won't spend too much time on that. Okay, executive sessions. Okay, we've already learned that exempt sessions, the first thing we talked about, are different than executive sessions. Executive sessions are subjected to the OPMA, meaning we've got to announce that we're going to be executive session. We've got to note that. The grounds are narrowly construed. They're outlined in law. The purpose of the time must end. It must be announced before exclusion, before we go into it. We can extend, certainly, but we cannot end early and go back into session early. Does that make sense? So, and part of that is because the public might not be coming back, and so if we're done early, we've got to wait until the time expires and go back. So any questions on that? No? Okay. And the reasons for executive session, this lists them out. You know, something to note here, we sometimes say, you know, personnel is one. There really isn't one for personnel. There's much more detailed in terms of what that is, and it's the board bullet to evaluate qualifications for applicant for public employment or to review the performance of a public employee. So that would really, so it's not just like personnel generally, it's gotta be targeted for one of those purposes. And even though in that the final action must be taken in public session, the hiring, determination, something like that must happen in open session. The last bullet point, to discuss with legal counsel litigation or potential litigation that's either been threatened, that we believe is going to be commenced, or we have public knowledge regarding discussion may result in adverse legal consequences. In that circumstance, we have to have an attorney present, either by phone or in person, and we only can discuss the matters that were contained in that announcement. So if we are appropriately in executive session under multiple of these, we can talk about multiple things. But if we're just talking about potential litigation, we shouldn't change gears and talk about an evaluation. Even though that could be an appropriate reason, if it's not noted, we can't change course. And also our conversations, let's just say we want to then start talking about something totally unrelated and we're in exec session, we need to be careful to only stick to the topic which we've announced. Okay? Yes, Director Hill.
Does that also apply to, could we notice things that we're gonna possibly talk about and then not talk about them?
Yes, I think that's okay. That is okay.
Can you just put that out there, I guess?
I've had boards that just preemptively put out an executive session and then maybe not everything is discussed. That's okay.
You need to notify the public that you hadn't talked about those things.
You do not. You do not need to disclose that you did not have a conversation about that. Okay. Great question.
Would it be inappropriate in executive session, let's say that it does end early and you have 5 extra minutes before regular session starts, right? Can that time be used for non-substantive discussions such as, should we have tacos at the next meeting or pizza?
Yeah.
Do we meet at this Starbucks or that Starbucks?
I think that's okay. Again, you're not taking action, deliberation, discussions, considerations that are of substance. Whether to have tacos or burgers, I'm gonna see nothing in the dais about that. You're fine, right? There's no action that needs to be taken. Okay.
Always tacos.
Always tacos, it's the right answer. All right, moving along, zipping along. All right, executive sessions, I'm gonna skip some of the cases. Confidentiality, big one, important one, okay? So, in your position as a board director, you are gonna have access to confidential information. Confidential student information, confidential employee information, information related to litigation. And part of your oath, part of your municipal officer code of ethics is to keep that information confidential. And if you breach that, if you share information that is considered confidential, either from an executive session or in some other capacity in your position as board director, you can be committing a violation of the municipal officer's code of ethics. Okay? So we take that very seriously. Some ways in which I want to put a fine point on it though. Attorney-client privileged information. If you're in executive session and counsel is discussing attorney-client privileged information, that information is protected and recognized by law, meaning my conversation cannot be disclosed. You could never be forced to testify about our conversation. Every court recognizes that privilege is protected. And there's other privileges in the world that exist in the country, but this one, attorney-client privilege, is the one that is relevant here. If you disclose that in the supermarket, on Facebook, to even your spouse, okay, to someone that does not have that ability to have that attorney-client privilege, it is weighty. Okay? It is weighty. And I can tell you as an attorney, if I know that attorney-client privilege information is getting waived, I get really nervous. Because then I don't know if I can give information that will be kept in confidence. Okay? It makes me reluctant to want to give advice if I know it will be kept in confidence. So I can't stress this enough. I know as a public entity, we think everything should be transparent. This is a piece though when we talk about attorney-client privilege, information that's shared in confidence, we've got to keep it confidential. Okay? Any questions on that? Yes, Director.
I just remember reading at one point about if things that are discussed in executive session, they're not meant to be in executive session. Say you go into that meeting and you do one of the things you're not supposed to do. That it is beholden on every person in that meeting.
Yes.
That they come out of that meeting and make sure the public is aware of what happened because it was no longer appropriate executive session. Is that correct?
Well, I think as board members, you all have a responsibility. Staff, you have a responsibility. We as board counsel have a responsibility to make sure that we're adhering to the rules. So I would expect, and I will, if I'm in the meeting and I see that, hey, it's supposed to be an executive session, or we've used the wrong title, I will call that out. If we feel like the conversation is veering course, I would expect, hey, we need to stick to the topic at hand. At times we can miss the mark. I would expect us all to be trying in the same regard. Now, as to what to do afterwards, I don't have a specific protocol as to what to do in terms of what you need to do afterwards as a board of directors. You need to disclose that to the public. I don't weigh in on that. I would say though that we all have a collective responsibility to make sure that we're adhering to the rules. I don't know of any rule that says we have to go out and disclose what exactly happened. I might need to see the case-by-case basis on it.
Yeah, I guess my question was more along the lines of if you went into executive session and say something happened in there that wasn't supposed to happen
Sure.
in executive session, that particular thing is no longer in executive session. It doesn't matter that it was in executive session because of the fact that it was either illegal or against a rule in OPMA that you would then know, like executive session does not apply because you did not appropriately handle the executive session.
I would say the exception might be attorney-client privilege, because I don't think that one individual can be waived. Like, the attorney-client privilege, even if you weren't appropriately in executive session and information was shared there, I don't think that would still give an individual the ability to share confidential information, attorney-client privilege, because that belongs to the entity and has legal advice attached to it. So even though you violated the OPMA potentially, which I'll take your word about it, sure, it's still, the remedy wouldn't be to disclose confidential information in that circumstance, because I don't think that waives privilege necessarily. It's kind of separate law, right?
Well, I can understand that. I guess my concern would be that, say there is something illegal happening and you don't disclose.
Right.
You don't make that aware of it to anyone. How is the public ever going to be aware that there are illegal things happening in the room?
I I appreciate the question. Just responding just off here, I would say, I don't think there would be a problem for you to say, I believe there was inappropriate information shared. I think you could certainly let the public know that without any violation. I would stop of stating, here's the information, here's the confidential information I'm gonna share. That was attorney-client privilege, if that makes sense. So I think going that next step to share that information, not the fact that the conversation happened, but actually sharing the substance of the legal advice, I think would be a problem.
Okay, but obviously the legal advice shouldn't be illegal in and of itself. It would be something that happened outside of the advice given by the
Correct.
legal counsel.
I just wanted to make that distinction of sharing the confidential information. I don't think that would allow you.
But also Megan's, President Morgan's, example that we're talking about, what we're having for lunch tomorrow, right?
Yeah.
That is not privileged information, that is not executive session information. If someone shares that, it's not, because it's not part of that.
Correct.
If someone does share it outside of executive session, my understanding is that doesn't matter,
Correct.
because it wasn't. And would that also apply to, say, things that you say you're going into executive session to do X, but you do Y? Well, Y wasn't noticed, so how is it possible
Yeah.
that it's part of executive session at that point?
I would say, without having every potential circumstance in front of me, the one that I would exempt out of that conversation would be attorney-client privileged information. I want to be very careful about sharing that at any point. If a meeting wasn't appropriately noticed and that information was shared, and it's not attorney-client privilege, that might be okay. I'd have to know more about the situation though, as opposed to.
How do you make it a determination of what is considered part of attorney-client privilege?
Yeah.
And what is not in that case?
So attorney-client privilege information is provided by an attorney connected to a litigation matter or a matter that results in litigation, right? So when counsel is giving you information, whether through your previous counsel who would give you advice via email or come to your meetings and give you advice, or counsel that you've retained as outside counsel, that information provided to you in a meeting, any of the work product associated with it, memorandum reports, emails associated with it, and the materials contained therein are protected under attorney-client privilege. Right?
What happens in a situation, like say we're in an executive session, and a non-board member then releases information from the executive session, does that waive attorney-client privilege for everybody?
So that's a very technical question. It cannot be waived by the non-client, okay? So the question becomes, who is the client, right? The question can become, as board members, you are the client. If you are, an attorney is representing you, in reality, they're really representing the interests of the district, an extension of the board, okay? And so my concern would be if individual board members or staff, agents of the district are releasing it, it would waive privilege.
For everybody else?
For everyone, potentially, yes,
Okay.
potentially, yes. Now, if it's a non-agent of the district, and they got it inadvertently, sometimes there's inadvertent disclosures, that happens, that does not waive privilege.
I guess, so an example that would help me then is like, say we're all meeting,
Yeah.
we're being sued for something. And then the next day.
This is hypothetical.
Hypothetical.
Never would be sued.
Yeah, and then let's say Ms. Curry goes out and shares information from that
Sure.
meeting. Does that now waive attorney-client privilege?
Potentially,
for
yes.
Everybody that was involved?
Potentially, yes.
Okay.
Yeah, potentially, yes. So that's why we want to avoid those.
But to clarify, that's not like, okay,
We're all
all
good.
hands off, we're gonna be able to talk about everything no matter what now.
Correct. I would still say, again, we're talking theoretically, I know we could be potentially put real facts on it, but in circumstances, how do you know whether you have an attorney-client privilege? Because you safeguard it. And so if there was an inadvertent disclosure or if it was released by accident, I would want safeguards in order to prevent any further. But if all of a sudden there was one release by a staff member and then everyone is releasing the information, you certainly don't have privilege.
I see, okay.
But if you are putting steps into place, especially if there's an inadvertent disclosure, wasn't necessary, and you immediately try to cure that, you're gonna maintain that privilege potentially. Okay, because you intend, a lot of that's the intent. Great questions, love it. All right, last piece is just in the course of your role as a board director, you will receive student and employee confidential information, and we are required to keep that confidential. That might be student names, that might be employee names, personnel matters, hirings, someone applying for a superintendent position somewhere, those types of things, that is confidential information that cannot be shared. Okay?
But that doesn't apply if there's, say, there's a complaint brought against the employee that goes into executive session with us, because we're giving them the opportunity to have it privately handled with us, correct? And at that point, that employee, decides they don't want that done in executive session, they want that to be in public.
In public, yeah.
That is a right that they have, correct?
Correct. There are circumstances in which a hearing can be conducted in public, and certainly if it's conducted in public and not private, then information is considered public, it's not a violation to release public information.
I think my question is connected to this.
Yeah.
Say, something's happening and then the board gets subpoenaed, who represents, or like, what happens in that case? Like, say there's a teacher grievance.
Yeah.
And they didn't like the decision that happens, and so now they're suing the entire school board, and then we get subpoenaed
Yeah.
to either testify. Who, do we
It's a very,
all go
that's a very
together,
great question,
or?
very great question. So, there was the other board meeting, which we heard for a long time, and a lot of questions about, well, Curtis, who do you represent? And what is, who's the board's attorney, right? So there's questions about representation, and, I can tell you, or when a lawsuit comes and it's against the district, then individual board members are named too, right? Which can happen as well, right? And it happens a lot of times. Lawsuits come, superintendent, you're probably gonna be named, board members, you can be named, they might be served personally, well, okay? So I would tell you this, that, the legal theory, I won't spend too much on the legalese, but normally what you're looking at is whether or not the employee or board member was working in their official capacity, right? Meaning, was this part of your official capacity or what's called the scope of employment, or the scope of representation as a board member? 99% of the time, the answer to that is yes. Meaning, being sued in your individual capacity would be moot, and in most cases, you would move to dismiss you. Therefore, I can represent the district and you because our interests are aligned. Now, there could be situations in which a bus driver gets drunk and hits, causes a horrible accident, and we're gonna have to argue, no, that's not within the scope of the employment. You drinking on the job, we're gonna, our interests are diverse, we're not on the same page, right? So you're gonna have to get your own attorney.
I think I was the
Right.
board case.
I know.
Literally
I
went
went
to the-
from 0 to 60. But it's still the same in the sense of like, that question of, if you get a subpoena, I will talk to, not always me, but the attorney for the district will talk to teachers and say, we're not a part of this matter, you can respond to it, you're not in trouble, you don't need your own attorney, we're on, there's no, conflict of interest, that sort of thing. And so, that comes up quite a bit, right? And those other examples were the ones that I might come up to.
Okay.
So I guess your point there was saying that if someone were drunk at the wheel and did something.
Yeah.
That they would then be held accountable themselves personally, because they.
They could, yeah.
They could be theoretically.
Yeah, I would reserve that argument.
Yeah, and so, would the same be said for someone committing a crime in their capacity as, an employee of the district or a board member of the district?
Intentional crimes would probably be outside of the scope.
I see.
Intentional crimes would be. Okay. But like simple negligence, like you didn't know a rule, I would say would be within the scope. If someone has made a mistake, like a teacher accidentally did something in a classroom, it's probably within the scope and it would be covered by insurance company. Intentional acts, crimes, getting drunk on the job, those are likely not within the scope of employment. Right?
I'm just curious, I was just, for
Good tangent.
example, like TikTok thing that's happening.
Yeah.
With, like an entity being sued, like I understand like individual, but like
Sure.
if a group is sued, like who is the person that would represent the board?
Yeah.
In that case, would that be?
So in this case, what happens is if the board is sued and if the district is sued, we have coverage for counsel who would represent the interests of the district, including the interests of the board members. And assuming the board members were acting within the scope of their representation, they would be covered. And they wouldn't be personal counsel. we would be required, if there was a conflict, we would disclose that to you and say, guess what, Bergstrom, apologies, you might need to use your own attorney. In my 20 years in my career as counsel for boards, it has happened very, very little. Very, very little. Most every time it's come. Now, knock on wood, right? Whatever. Sorry. Yeah. Good question then. Okay. All right, let's keep it moving. Really quickly, public participation. I just want to share some of the guidance related to, we have public comment at board meetings and what's allowed, what isn't allowed. Public comment has First Amendment protections. And so, I tend to be pretty careful to not want to regulate the content of the messaging. We can have what are called time, place, and manner restrictions. We can tell them, when they can talk and how long they can talk, but I want to be very careful to not regulate conduct or regulate the content of the message, right? Be very careful on that. Public comment may be taken orally, and if we accept written comments must be distributed to the board members. We can set a reasonable deadline to the public to submit their comments. We do all this appropriately. So, we can put, next slide, time limits in terms of what, and we do that. We can stop an individual from speaking if that individual is not recognized by the board. But I will tell you that, and I know we have restrictions about not mentioning personal issues or do we say something like that?
You can talk about personal issues, I mean, I think everything here is personal, right?
So, yeah,
But you can't mention, a public or school employee by name or in a personally identifiable, such as the principal of X, Y, Z.
Okay.
Although I have to say that we are maybe a little more lax on that one.
Here's what I would say about that. I don't want to change everything we do. I just want you to be careful because if you really honestly did that and never allowed that to happen, you'd be okay. What I worry about is selective enforcement. So if you're allowing positive comments about principles, then you probably open the door to negative comments. So just be aware of that. And I would say,
As long as I've been here, but Tim, you've been here longer than I have, we've never stopped a comment.
I would be,
because of
yeah,
it.
I would be very careful to not gavel someone out. The worst case scenario is they go on for 3 minutes and then it's done. It goes out in the ether, and I think the most powerful response to that is no response. Right? If someone is saying something we don't agree with, I think it's, especially if they want to go viral, we've seen a lot of groups that want to go viral, they're saying things that they want us to gavel them out because they want to go viral. I would say it's better to say that, personally, right? First Amendment protection. So just be careful on that, like selectively, like if we have a rule, okay, because I guarantee we're allowing positive comments, so we need to be careful about restricting negative comments. Does that make sense?
I think I think as a board, the one thing I've had a little bit hard time is if it's against a student.
Yeah, students are a different story.
Yeah.
Right,
So
students are a different story.
They have no choice.
we have big shoulders for
FERPA protected
adults.
information, FERPA protected, and that, I would support you on that. And even if we're technically going to potentially get a First Amendment claim on that, if it's involving the safety of a student or private information of a student, I will 100% defend you on that.
And we've had a couple that have come close, and I think one that we might have encouraged somebody to move along
Yeah.
into how the situation was handled instead of about the particular student.
I understand, yeah.
And it's not as, I guess, as cut and dry with this, like if we were to allow people to speak to a student's, like, the good things that a student was doing in a board meeting, but then someone wanted to, say, denigrate another student, we wouldn't be beholden to the fact that we allowed this other student that we talked about in a positive light. We would still be okay to say, I'm sorry, you can't talk about this other student in a negative light.
Yeah, I would defend you on that.
Okay.
Yeah, for sure. If there's disparaging things being said about children, okay, specifics. Yeah. And I had one in which, it was being said about, some of the student board reps that were there.
Yeah.
Yeah, and we tried, this is not Ken, this is another one. Yeah.
Makes sense.
So we support it, right?
Yeah.
Okay, so quickly, just, AG opinion, guidance, if someone wants to come in video, they can, if they wanna have their own video, right? We had a First Amendment auditor show up here not too long ago, I don't know if you heard about that. It didn't make the news go viral because we didn't shut it down. They wanted the video, but there's tons of viral clips you can find, right? People want, but they're allowed to do that. There's new guidance guidance in regards to school board recordings that became effective this last summer, which basically says that we have to provide recording, that we've always done this, so we're doing this already. So there's nothing that really has changed for us, because we're already providing these records, yes.
Public comments, time, place restrictions. Right now, we do not have a policy restricting, basically, public comments are a half an hour at the beginning.
Yeah.
And then indefinite at the end. That is not, my understanding, that is not necessarily standard in other districts will limit it to an hour or something like that, or a number of people per night.
Probably yes. I'm gonna be honest, with the exception of maybe Seattle and a couple, public comment's pretty light in other places. And so, yeah.
Which would actually work in the other ones, I actually have seen a similar structure that you have, I've seen the gamut. So if that's a structure that works for your board, I would say that it's not often that, we happen to live in an era where there's more public comment than there traditionally has been, so I think there's all different practices.
Okay, but I guess my point is, and I think you agree to that, it is not required that public comment is indefinite.
Correct.
It's not required.
Yeah, not required. Up until recently, up until around COVID time, there was new legislation. Public comment wasn't even required at all, right? Only with recent legislation post-COVID has it been required. But if you do it, I mean, now you're required to do it, but you need to, any restrictions on it have to be content neutral, meaning you can't say, no comments about X, or, so once, if you say only an hour, then you gotta cut it off, even if they're positive, and even if it's gonna be the kids that wanna present on something, you're saying, no, you're out of luck, right?
Yeah, no,
Content.
by the way, I'm not saying that we are doing that. I'm just thinking, I mean,
Yeah.
is there a point, like, it's 12 AM,
Right.
can you cut it off?
I would say any restriction probably would need to be publicized prior to the meeting.
Fair.
Right? You wouldn't want to do that at the dais, right? At the time, we're all tired, we're gonna cut off, and you're done.
Okay,
I
but you
would
can
be
postpone the meeting for another day.
I certainly think you could. I know, without having that published beforehand, I would hesitate to want to cut off public comment if we've allowed it to be indefinite for that meeting. If it were published prior, I have less concern.
Would it be better for us to do it in the opposite way, so that, let's say we say we're going to give 2 hours in total of public comment space, and if we decide we want to extend that and say, we see that there's a lot of public interest in this, and we want to give people as much time as possible, so we're going to extend it because we think it's important, would it be better to go that route and have like a rule that says 2 hours, but then we decide as a board, we're gonna extend it?
Yeah.
And we're gonna push it to 3 hours instead?
That's not a bad consideration. I would say my only response to that would be, if we're always extending it and it's always the exception, then why do we have a rule? But it's fair.
But I guess that way, it just makes it so that you do have this constraint that says, we will be done in 2 hours, but if for some reason there's a lot of interest and we decide to extend it, then we can, right?
Right.
It's not, we're not beholden to that
No,
completely. all
you
the
could
time.
extend, for sure. Okay, lastly, violations of the OPMA. Anyone that knowingly violates the OPMA is subject to a civil fine of $500. The first violation is $1,000 for each violation thereafter. And there can be other sanctions associated
What are some examples?
of violating the OPMA, or say, I think that it's a civil fine, so there's no criminal. I think that it just talks about sanctions. It doesn't give examples. I've not seen it tested, so I struggle to know what else, but I would say if we're getting any of these, let alone multiple of these, then we need to reevaluate what's happening. Right?
And I imagine that's rather difficult to prove, because it's all based on, like, your intent.
Correct.
Right.
Knowingly,
Knowing,
right,
so-
knowingly. But we certainly want to be able to demonstrate that we've been trained in this, that we understand. If you're asking the question, you're saying, hey, can we do this? Then you're in a good position. It's the boards that don't even ask that are just out there flaunting, that's the problem.
Right.
All right, that's OPMA. Any questions on public meetings? Okay, I'm gonna move to PRA. PRA is gonna be quick. That was the big ticket item, right? The rest of this is gonna be much quicker. PRA, what I want you to be aware of is the work that we do, the records that we create, the emails that we send, the agendas we create are public record that need to be retained according to a retention schedule that's published by law. Here's the piece that I want you to be aware of. A court case from 2015, which basically says that text messages sent and received by public employees in your official capacity are public records of the employer, okay? Even if the employee uses a private cell phone. Okay, this is a case from 2015, which means the conclusion here is do not conduct agency business on a cell phone, right? Be very careful. It's so easy and it's so convenient. It's, you know, we send a text message now. The text message, not everything is conducting agency business. For example, even if you sent a birthday celebration, you know, hey, happy birthday to a fellow director, is that conducting agency business? No, I'm not worried about it, right? You know, a picture of your niece's graduation, not worried about it. But when you are conducting business, meaning you're discussing, deliberating, you're doing all of these things, not only are there OPMA considerations, because you could be conducting a meeting, there are PRA considerations, okay? Especially if it's your private phone. So, in circumstances, I have had Public Records Act requests, not necessarily in Kent, but in other districts where the public has said, I want every text message communicated between the board members on their personal cell phones. And I've got to contact board members and say, have you sent text messages back and forth discussing, hey, are you going to vote on this? How are you going to vote? Or, you know, conducting potentially agency business. And that board member has to produce those messages. And if they tell me, Curtis, I deleted them, okay, which has happened, I've got that case right now, it's going to litigation. I have to basically argue that, one, they weren't supposed to be retained, or if in the event that we deleted them after it's been asked for, we probably don't have to pay statutory damages, right? Takeaway is, what's better than sending a text message? Calling, right? Old school, you're not creating a record. Having a conversation in person, as long as it's not a meeting, your whole
Now, the
board
call
there.
itself is still a record, right?
What's that?
The call itself is still a record.
Sure, yes, the call law could be, potentially, yes. Yes. See, if I just prove that, I don't know what, oh, you talked to a board member, I don't care about that, record is not damaging for any reason. But it still could be a potential record, but more importantly, be very mindful of when you're creating records, and don't do it haphazardly, and be very careful. I would not have any board text messages where you're all on it. That's potentially a serial meeting, it's also got PRA considerations. You don't want your personal cell phone to have to be subject to disclosure. Can we do that? Yes? All right, thumbs up. Okay.
Now, does that only apply to us discussing either with the district or with ourselves, or is it like, if we are just chatting with friends, like?
Certainly not. So again, here, text messages sent by public employees. So let's just say you're communicating with another staff member that happens to be a member of the Kent School District. They happen to be a friend of yours, and they're an employee, they're a custodian. In your official capacity, are you communicating them with them as a board member? Probably not. You're probably just talking to them about how to be, right? And so in that case, you're not really talking about anything related to the agency business. You're not talking about your position as board director. But just think about it this way. If you're saying, in my position of board director, and sometimes community might reach out to you and say, you're a board director, and they text you, and they want your opinion on something, and they texted you, there might be a better way to respond. Hey, let's talk next time I see you. Or send an email. At least email, we know it's going to be retained. So email me, you know, because in that way, you know it'll be sent to your district email, that'll be retained, we'll have a record of it, and you don't have to worry about it being on your personal cell phone.
Or if you tell them to text your district phone.
District, do you have, does board members have district phone?
No.
There we go. Okay, problem solved. Because we know that's going to be retained, right? We have, still be careful about serial meetings on your phones, but and I would keep your personal cell phone, I would not conduct any agency business on it at all.
Now, what if someone like I don't know, something silly happens and you make a joke or something from the dais, and someone brings that up later in some conversation. I mean, obviously you're talking about things that happened while but
Yeah.
it's not something that has any bearing on anything, and you're not discussing any business about the district, you're just something silly that you said, and
Yeah.
it was something that they thought was funny, but they happen to also be an employee or something along those lines, would that also?
So is that, they're texting you it?
I'm sure, I don't know.
So
I'm just saying,
I would
like,
just probably, anything that has to do with your role as if it's your personal cell, I wouldn't do it. I just wouldn't do it. If it's anything about you being a board member and your role as a board member and it's being sent to your personal cell phone, I would support it.
Yeah, I didn't know, like, my mom will say something, like, she worries about me, because I took off and went outside to
Sure.
get some air. And
You know,
so
if
she's like,
if mom is saying, hey, are you okay? I saw you in the meeting, and you say, Mom, I'm okay, I can defend that. Don't worry about that. Don't worry about that one.
Yeah.
I'm not gonna, you know, if that record's gonna be requested, I'm gonna say that's Don in his individual capacity as a son and not in his official capacity as a board member.
Yeah, I was just wondering what that.
Yeah.
point is, like.
That's an example of one I wouldn't say you need to disclose.
Okay.
Right? There's no retention value of that. That's not you, yeah.
Criticize.
Yeah, superintendent.
Having been in the district a long time. Related to this, but really the building is using the equipment that the district has provided is what we've always pushed for, right?
Yeah.
So that you do not have to worry about those kinds of things.
That's
Even
right.
when you have whatever go down, we say, we'll give you another one, right? Because you don't want to conduct business on a.
You're lucky that way, not every district provides
I
that.
know that.
So I'm happy to provide this training. Amy and I were in another district not too long ago, they didn't have cell phones, and so they have to be very careful, right? So not every district provides it, so there you go. Benefits of being a director. All right, last subject, PDC, Public Disclosure Commission. So this is about using public resources in furtherance of election or election activities. Okay, so we want to be careful here. The rule, the RCW says no elected official or any employee in his official office can use basically the public office or agency facilities in support or assisting a campaign for election. Okay, promotion or opposition of any ballot proposition. Right. So I'm going to get into some examples of what this potentially could look like. So for school boards, you can collectively, it's permitted for you to collectively vote to support or oppose a ballot measure at appropriately or properly noted meeting, where opponents of the measure are given equal opportunity to express views. So you could vote in a resolution to support, right? You have, right? So in that case, you can do that, right? And you have to have public comment on it. So that's one piece where I've seen board members, so where you have, and we're gonna discuss a resolution to support a ballot measure, you have to allow public comment on it, okay? Assuming you do that, then you can collectively vote, you've taken a position on it, you can go forward, all right?
Can you continue to talk about it though?
I believe so. So if you go here, you may, let's see.
Because
If the board has
we've
adopted a
talked about that.
resolution, the board member can speak on behalf of the district. Okay, so you can, as board president, make a statement. But I know it can be dicey, so we're just giving you some lines here. I might not want you to go too much farther than that, okay? So I'm not going to keep your opinion. If you're not, if it comes here, if the board has not adopted a resolution, can you speak as a member of your own personal opinion? And you can still do that, right? So you can potentially, if you're not using your resources, and that can get confusing, but what it says here is, school board members may engage in political activities on your own time if no public equipment, vehicle, or facility is used. And from the cases, an official may use his or her title, but should clarify that he or she is speaking on his or her own behalf and not speaking on behalf of the district. So if you did some sort of op-ed or something like that, you potentially could do that if it was not using your role as a board member. Just saying, hey, I'm Megan, I'm a member of the public, you do not lose that right. Okay?
But, okay, I guess more, the board has made, let's just say, in a hypothetical world, we have all come together and said we support a KSD levy.
Yeah.
And that levy's on the ballot, and we've all voted on it, and as a board, we collectively have agreed to support it.
Yes.
From that moment on, can we still continue to talk, let's say, in like a board report? Hey, levy's coming up, we support it, you should support it too? Or are we limited to,
Producing only content neutral.
yes,
So I'm gonna tell you, because we also have restrictions that say any mailings we send out have to be fact neutral,
yep,
right? We want to just provide facts. I'm gonna tell you that even if you've adopted the resolution, I think you're technically could continue to speak, but I would want us to have layers of protection here.
okay.
So I'm gonna tell you that let's just keep it neutral, even so, even if we've adopted the resolution, I would still want you to adhere to that, because I want to avoid a PDC complaint.
Okay. Well, then I apologize for.
Yeah.
Yeah, I mean, the board has adopted a resolution, you're defensible. I have 2 PDC complaints in front of other boards right now for this very reason, and they did everything right, but I want as much protection as possible on this because public's watching.
Okay,
So even if you've adopted the resolution, I think you should just keep it fact neutral.
But as far as that goes, because we can do that part, right, like we didn't pass a resolution.
We did.
So
They did, yeah.
we have,
For the
You're
levy
right.
question,
okay.
when you say back neutral, could that also encompass, paraphrasing or calling back a conversation? Like, hey, we have a discussion about levy, just wanted to read it, or that?
Yeah, that's fine.
That would be okay?
Yeah, in fact, in your mailings, because I've just done research on this, because I'm responding to this PDC complaint, you can also send out and provide information about consequences of the levy that you pass. Even if it's, as long as it's factual, like but you can't like use inflammatory language like, you know, every school's gonna close and, you know, our court show, you know, can't use inflammatory language, but you can provide fact neutral information about what are the consequences of failure to pass the levy. That can be included in the complaints. That's a fact neutral position.
Can I ask you a question about one that was on the previous slide?
Of course.
Only because this is happening, I think, out of Georgia, about the campaign and political actions.
Sure.
If a board member, we're all meeting.
Yeah.
If I'm connected to the KSD Wi-Fi, but I log on to
Oh,
my
boy.
personal device, and I send out a personal campaign email because I'm running for re-election,
And you're at the meeting.
and I'm just in the building or like connected
Yeah,
to the
okay.
district Wi-Fi, because I'm using the facility, does that consider a violation of?
It could be. I mean, you're there, it's during the meeting, you're technically on 5G, but you're not on Wi. I mean,
Like if I'm not
it's
using. my
enough in the
service,
ballpark though, it's enough in the ballpark where I think it would at least survive the first round of a complaint. We'd probably get you out of it, but I'd rather not have it. So I would be very careful. I don't know what's happening in Georgia, but I would advise to do that. Get some time and space away from that meeting and maybe you're at home.
I would also suggest paying attention to the meeting.
Yes.
Well, not like just in the meeting, but like say we're on break, but I'm still connected to the Wi-Fi in the building.
Oh, I see.
And I'm
We were on.
responding, but it's on my personal device, but because I'm on the KSD Wi-Fi, it's using district resources.
Yes.
That's the argument that's being made.
That is good, as an argument being made. You're using network, yep,
Yeah, so in that case,
yeah, don't do it,
do you think it would, okay,
yeah.
The network is like the device,
right,
equipment.
okay.
Yeah.
Yeah,
And
I
it says
don't know
here,
if that sounds-
directly or indirectly. So you're using facilities or resources directly or indirectly.
Yeah.
And you're breathing the air in here, so.
You're breathing the air that was produced by the ventilation systems of the KSD. All right.
I have one other question on OPMA, I guess, on the public comment. What's the purpose of public comment? Because this is something that's come up, and it's not that I'm trying to say it should be one way or the other. Is the public comment meant just for the public to comment to us specifically? Or is public comment broader than that? It means they're providing public comment to us, but it is also a public forum for that person to say their public comment to the public as well.
That's a very interesting question. I don't know if I have an immediate response to that, but I will say this. It is awkward in the sense that the board doesn't respond, right? We don't have a response, so it's not an interactive process where you're saying something and I'm answering the question you're giving me. So I do think the public has the right to share the information, whether it's directed at Director Cook or the board or the district in general. I wouldn't limit it to say that it's just to the board. I don't necessarily think that that's necessarily the case. I don't know if my opinion on that matters. I don't know if I have a strong opinion on it, but
I guess the reason I
That's
ask
the
is.
board's meeting.
it's that's a fair point, President Marniel. In what way would it matter?
The only time that I see it mattering is just that from an ADA compliance issue. Say there's someone that can't make a verbal public comment, so they write a written public
Okay.
comment and
Sure.
send it in. They are not afforded the same rights and privileges of the person that can speak, because the person that can speak is getting it out to the entire public, and everyone gets to hear it. Currently, the way that our rules are set, you wouldn't get that same thing with us, because you would have it just sent to the board, and the board doesn't share that information necessarily with the general public. And I don't know that that's correct or not. Either way, I'm just curious as to whether or not, if it's meant to be a public comment for the public, then I feel like that makes it different than if it's a public comment for the board specifically. Okay, fair point.
I would say in that situation, I would encourage somebody who feels like that there's an accommodation that needs to be met. I cannot imagine a moment where we would not find a way to try to accommodate somebody if that's really the holding back is an ADA accommodation. I've never, we bent
Yeah,
over
we have it.
backwards to make sure we had, translators, even on nights when nobody showed up that needed it. And so I couldn't imagine us being in a situation where we wouldn't want it.
I don't think we're trying to make it really advanced. I just mean that, like, as a whole, like, what is right? That's what I was thinking is, if it's meant just for the board, that makes more sense. If it's meant as a place for the public to be in a public discourse, even though they're not getting discourse from us, I don't know.
Yeah.
Yeah, part of our trainings, previous trainings with Sandy and all, back to I think someone mentioned that it's the board conducting a meeting in public.
Yeah.
Versus for the public. And that takes into account, there's no like back and forth. The meeting must have an opportunity for them to have, and I think that's the other piece. What opportunities are there to have public comment? And back to President Margell's point about ADA, they're all different reasons that one form or the other might be best, but there may be a combination I might need. Are we doing that? And it doesn't change the fact, we're still having a board meeting in public. We're not, we're working with each other, we're working in public with each other conducting business. And we just have to make sure we have those opportunities for them to be able to provide comment, whether written or.
Sure, your response. I've been going for an hour, and I wanted to keep it about that. The only last piece I wanted to talk about that was on the agenda was policy versus procedure, just a quick explanation of the differences between policy versus procedure, and then we'll turn the time over to Amy, who's going to take us to the next portion. So just generally, policy versus procedure, WASDA does have recommendations of both policy and procedure, and we've adopted those mostly. The biggest difference between policy and procedure is, from the board's perspective, policy requires first and second approval by the board. And that are the rules that have to be adopted and approved by the board. First and second reading, voted on. Whereas procedure, I think we bring to the board for informational purposes only, but those are kind of like the actual policy or the actual implementation, like the standard operating procedures. Those can be adapted without coming to the board. That's more operationalizing the policies. And so that to me is probably the biggest difference. There might be the difference between the RCWs versus the WACs. And I see a lot more variation from district to district in the procedures. The policies tend to all look the same. They tend to be a little bit shorter, and the procedures tend to be a little bit more restrictive. But the biggest piece for you all is policies require board approval. First and second.
Procedures don't then?
They don't. They come to the board for informational purposes only if the procedure's been modified. But generally, staff have the ability to kind of implement and change those procedures on an as-needed basis.
And so what happens if, for instance, I'm not saying this is happening, but say the district ends up deciding to do things completely outside the intent of what the board had put into policy? What is the remedy in that situation? The board is obviously the one to set those policies, but
Sure.
the procedure is something separate, and they don't necessarily have to be.
I would expect that the procedures enhance the policy, that you wouldn't have a policy that says, one thing and then the procedure implements it in a total opposite way, right? I would expect that the policy, if you're changing direction in procedure, I would expect the policy would have to be modified too, right? So that's my first